Can't see down the hallway now. Normally I can see people. Yeah, there may be another councillor arriving. Ah. Well, good morning everybody and welcome to the Council Bylaw hearing this morning. The hearings are being recorded, so I ask submitters, there are 3 submitters, when you come to the table, could you please turn on your microphone? I think most of you know that. And also there will be 10 minutes for each submission, and we're hearing 3 this morning on the bylaw. Do we have any apologies? Thank you. And Councillor Donaldson. And there appear to be no others. Do I have a mover for the... Thank you, Councillor Gould. Seconded, Councillor Rotorua. All those in favour, please say aye. Contrary? Carried. Thank you. Are there any declarations of interest? Councillor Serenk.
Declaration of interest in the submission from the Rotorua District Residents and Ratepayers Society. Will not take part in any debate on it, nor shall I vote.
That's submission number 1. Thank you for that, Councillor Serenk. Yours also. Thank you. Submission number 1. Thank you. We have received 2 late submissions which I have agreed to accept, one from Peter Duncan and one from Bruce Horn, though I can't see Bruce Horn here yet, but he knows his time for hearing because they were both related to both the signs on the roads and the traffic bylaws. So I call for a mover and a seconder to receive the report. Thank you, Councillor Gould.
Point of order, Madam Chair.
Yes.
Do we have written copies of what these 2 newly accepted submitters are actually going to say?
I'm sure there will be a copy. Yes, yes, both are on the desk, but you don't appear to have them. Thank you. Thank you. We'll sort that now. Good point. And Bruce Horn's bringing his copies. All right, we jumped in a bit there. A mover and a seconder to receive the report. Move. Second. Rakawatate. That the report, the bylaw review submission hearing be received. All those in favour, please say aye. Contrary? Carried. Right, we move now to the submissions and we ask first to the table Peter Duncan, the wedding guy. That's your brand, Peter. Welcome to the table. And that's a submission before us.
Madam Chair, may I ask, is there a time frame or time limit put on the submissions during the...
Yes.
So that 10 minutes,
10
is it?
minutes.
Thank you.
Thank you. Peter, and you've got your microphone on. Good morning. Welcome.
Good morning. Thank you. Kia ora, and thank you so much for allowing me to be here today. Madam Chair, thank you for accepting my belated submission and affording me the chance to share with you my thoughts on the amendments to the signs on Road Bylaw 2008 to address the temporary signs, event directional signs and temporary signs sting. My interest is purely as a business owner in Rotorua and relates specifically to the use of the temporary event signs in our city. I appreciate that I'm just speaking to this as far as you're reading it verbatim as I am. I own and operate the Wedding Guy Company, and it really embraces a number of events in Rotorua. For at least 2 of these events, we employ the use of temporary signage as part of our marketing drive leading into and on the day of the event. The use of temporary signage is a vital part of our overall marketing strategy and attracts both local and out-of-town interest. In the last 6 years, the use of core flute signage around the city has proved to be invaluable and getting and attracting people to participate in one way or another in the events which we're hosting. I certainly agree with that temporary signage should be for the purpose of advertising an event and not for ideas or statements that don't relate to a specific event. As per the definition, temporary event sign means a non-permanent sign advertising an event, including but not limited to an event that is educational, sporting, religious, cultural, charitable, entertaining, celebratory, exhibitive or competitive in nature. I would like to submit the following suggestions, which I hope you'll see as a value add to the current pool of suggestions that you may hear from today. First of which, the construction and placement of framed stands. This would create a consistency and uniform approach and ensure the signage placed on the frames are consistent with the dimension requirements of a typical call flute. You may notice around town when you go around and have a look at some of the stations where signage is, whether it be at the Ortonga roundabout or on the corner of Malfoy and Ranulph and other areas, that you will have standard call flute size and you'll have smaller sizes and all that sort of stuff. And some of those sites are pretty derelict, and while I appreciate they are on private property for some part of it, it would be great to have some measure of consistency and uniformity. I think it would also be of value to both the city and us here today to have something that is in theme with the city, and the council is doing a fantastic job, in my opinion, of the current refreshing of the city. I think it would be great to also have the signage do the same. Additional signs, second point really, additional sites be added that are council property that offer high visibility and high traffic flow. I've given you a graphic there of a sign that is, I think it's on private property, but it's by way of Kawerau Jet, a locally owned business that have got a purpose-built frame to house their image and promote their business. And again, I think that is certainly an enhancement on some of the signage or framing that has gone up. If any other businesses like myself, I've added, oftentimes gone with hammer and nail and some framing and just added to some other derelict piece of structure that's already there and hope for the best that it's going to hold up during the campaign. So it would be great to have something that's a wee bit more professional looking than what we presently have around town. My third point is extend the duration wherein event signage can be erected and displayed prior to an event date. And I would like to offer 8 weeks as a duration. As an event organiser, for the most part, 8 weeks is a good lead-in time to an event, and certainly a great lead-in time for anyone to be able to go past that signage over the period of an 8-week period rather than a shorter time frame. All of our signage to date has complied certainly with rules as outlined in the signs on Road Bylaw 2008, and in that regard I certainly don't have a problem with that. We also do not have any issue with the signage requirements, and for that short brief, again I wish to thank Rotorua Lakes Council for creating spaces throughout our city, and certainly I hope that we will look at doing something going forward that will further promote both the city and our events, and thank you again for affording me the opportunity and the chance to be able to share my thoughts as to how we can potentially add some value by way of the bylaw. Thank you.
Very succinct, and there are still 5 minutes, so are there any questions? Councillor Gould, Councillor Weeper, Councillor Sarank and Councillor Rokawatau.
Thank you, Peter, for your presentation today. With the email you sent to Rick Dunn,
Yes.
you've got a list of 4 suggestions. Number 3 is that extend the event date to 8 weeks. Would that include taking the signs down?
That would be the 8-week period, and thank you for the question. That would be an 8-week period which wouldn't include taking the signs down. So the 8-week period would conclude, and then you would have, I think it's typically it's 48 to 72 hours to have the signs dismantled.
Councillor Weeper.
Yep, mine was on the same question. Thank you, Peter, for coming in today. Appreciate your submission. So with the 8 weeks, so the reason you're asking that, is it because it's just your, like, there's no evidence that it's going to help. Is there some evidence
Okay.
or not? The reason I ask is I know we're only allowed, when we're electioneering for council, we're only allowed to put our signs up for 6 weeks.
Yes.
And people will often say it gets boring after a while and they don't see it anyway. So I just wondered your rationale behind needing 8 weeks. And my other question is also around the use of perhaps a frame. And we had proposed in the district plan to look at 6 sites. There was a bit of a concern, is that enough? Because we sometimes have lots of events. So I just wondered your opinion on that as well.
Great. Both great questions.
Even though I know it's online, there's a bit of crossover in the submissions. People be confused with district plan rules and our traffic bylaws.
Certainly. As far as the 8-week scenario is concerned, for any event that we are doing up to this point in time, there is, as you know, the 6-week scenario where we can advertise an event. That would apply both to our call flutes and to any road flags that we're using up to this point. To say that up to this point there have been some measure of elasticity around that 6-week period is an understatement. We have endeavoured as a business to comply with the 6-week scenario, and yet we have seen other businesses that have had events there and they've had an 8-week plus duration. We would like to create some uniformity in the way that, be it an event organiser or a business or whatever it is, advertising by way of call flute or a road flag, comply with a similar rule rather than having one rule for one person, one rule for another. So in that context, an 8-week, and dare I say, while your billboards are probably fantastic during electioneering, our events are a great deal more exciting by comparison, and so we want to attract more numbers, unless of course you're getting married. So,
Councillor Serang.
and the part B of that same question was, sorry, just refresh my memory. Yes, as far as the actual number of sites is concerned, the actual site numbers are fine. It would be how many billboards can be displayed on those sites at the same time. Our biggest concern is that if you only have 6 sites, and you need to, in our case, because we're a smaller business compared to some of the larger event organisers, we have to be very strategic in the way that we place our signage. As such, what that means to us is that we would typically, for our billboards, only have a maximum of 7 sites or 7 billboards that we can use. So if we are thinking about potential sites as to where to have placement, we always look for things with roundabouts or with traffic intersections, so people are actually taking a pregnant pause and having an opportunity to look at that signage before moving on. It also serves to minimise any distractions on the part of any traffic, so rather than being, seeing it in your peripheral vision, you're actually taking a pregnant pause to actually look at it. Is that helpful?
Councillor Serang.
Question is along similar lines as Councillor Wepper in regard to having a conformed frame. Is that what you're talking about? That everybody has to have the same kind of frame? And are you also saying that we can only have 6 or 7 sites in town that they be on? But why can't we continue with the policy we have, whereby if you get permission from the property owner, you can put your event on their property?
That's a great question. In 2 parts. The first part is, as far as the actual signage is concerned, the standard call flute size is creating a frame that would encompass a standard call flute would be ideal, because at least everyone is playing by the same rules. I appreciate that as far as budget constraints are concerned, for some organisations, a smaller sign is more affordable, and you can obviously generate more signs by way of result. And if that be the case, then that's fine. I think that there still needs to be a standard put in place so that we can work to the same standard or benchmark. As far as those frames are concerned, at least if we build frames, or council builds frames, or whoever builds the construction, be it through a partnership or a collaboration of sorts, be it local iwi and or business, whatever the collaboration may be, then certainly it means that we can potentially go for public land or council-owned land, as well as private Māori-owned land. In situations up to this point where I've had to approach private landowners, for example, some of that, it's difficult to distinguish who actually owns the land at that point in time, and sometimes you're encroaching on privately owned Māori trust land, and whereas other times you're obviously approaching private residences. There's nothing to say that people can't still approach private residences who are volunteering their fences, as is the case with Lake Road, where obviously that's a very popular destination for a lot of event organisers. So in that regard, there's certainly nothing to take away from that at all.
So you're saying that these 6 sites, the
Yes.
mythical 6 sites, those frames would stay there the whole time, only the content would change?
6 sites would be stationary, only the content would change. And sorry, the suggestion of 6 sites wasn't generated from me, it was generated from Councillor Weber. Thank you.
And thank you for coming, Peter, and putting your submission in. We wanted interest in this, so thank you for coming.
And again, I'm happy to help if I can be of practical help in this regard as well. Thank you.
Thank you. And now we call Reynold McPherson to speak. And I understand you've got a PowerPoint. Good morning.
Thank you. How does this work, Rick? Go to the next frame. I don't need the pointer. It's just that arrow there. Thank you very much. Cheers. Your Worship, fellow councils, tēnā koutou katoa. Thank you very much for hearing this submission from the Rotorua District Residents and Ratepayers Association. I'll move briskly through the presentation. The first, a little bit of background. We were launched in 2015 on the 25th of September. You'll recall our agenda has broadened from that originally settled on by the Pro-Democracy Society, though we carry forward their values. We now approach 400 members. So I'm speaking today on behalf of approximately 400 of our residents and ratepayers. We are, you'll understand, by far the largest residents and ratepayers association now in the Rotorua district. Our objectives, first, is to promote and advocate representative democracy. That comes from our previous life. Secondly, we still are very concerned that we gain compliance with the law with respect to operations, policy-making purposes, performance and governance principles. That is the Mayor and the councillors of our district. And finally, we would like to ensure that councillors give due consideration to the wishes of citizens when deciding policy. And the fifth, we want officials pleased to advise councillors impartially and act to implement council policy with fidelity. That's the values base that we come from. Now, the first point with regard to the proposed changes to the Signs on Roads Bylaw 2008, we would support the retention and most of the amendments to that bylaw. We note in passing that the objective of this bylaw is, and I quote, to control the problem of signs on roads to ensure, so far as is practicable, consistency in their placement, the safety of road users, and the functionality of roads. We agree. The second point is the definition of road specifically includes, and I quote, carriageway, curb, berm, and footpath, as well as motorway. So we support this clause 4 of the bylaw, which limits its application to the regulation of signs on roads. It therefore does not apply to signs erected on private property. But there are, nevertheless, a few reasons, good reasons, to question a few aspects of the proposed amendments. The first is there is an ambiguous definition introduced, and this ambiguity may enable prejudicial applications of the bylaw to temporary yellow signs on private property. There is a bracketed phrase in the definition, says, including but not limited to an event that is educational, sporting, religious, cultural, charitable, entertaining, celebratory, exhibitive, or competitive in nature. The difficulty here is it can be interpreted in two ways. The phrase appears to be restricted to events, as exemplified by the list. That's the first impression one gains from this logic. But it can also be interpreted as not being limited to events, such as activities that are not actually events or not quite events, such as asking questions of the public. This ambiguity, we would suggest, be focused on and be resolved. So to avoid the ambiguity, we would urge the deletion of the phrase, but not limited to, in order to confine the interpretation of this bylaw to the first and most plausible meaning, and we would say the most reasonable meaning, the intended. We hope that it's the intended meaning, but we would like that deletion to confine the interpretation. This ambiguity is replicated with a similarly ambiguous definition of temporary event signs, and it could allow, again, to enable prejudicial application of the bylaw to temporary yellow signs on private property. In passing, this is not central to our argument, but it's important to note that the statement does muddle the reasons used to justify the amendments and for limiting displays to 6 or so specified sites. I would suggest the drafters of this bylaw consider amalgamating those reasons or pulling them together into a coherent set. The reasons for the amendments, to justify the amendments, changes as the document proceeds. It leads to some confusion. The worry we have is these muddled reasons could be used to shroud other unstated reasons for the amendments that could be later used to exploit the ambiguity of definitions and justify wider applications across bylaw boundaries. There are reasons for us having these fears, and I'll come to those in a moment. We would also note that the need for improved traffic management, we wonder about that being an adequate justification for the new definition and for the introduction of 6 controlled sites, because from our reading, the government traffic management regulations are more than adequate to the challenge, and they already impose considerable costs on event organisers, and we would ask you to consider the wisdom of adding yet more red tape. But again, we urge the deletion of the phrase, but not limited to. We are particularly concerned about prejudicial applications of bylaws and plans that reach beyond their limits. We mean by that their legal limits. We note, for example, in a report in the Rotorua Daily Post on 29 October that the chair of the Waikuti No. 2 Trust reportedly took down a yellow sign on private land because he read that, quote, I quote, the council could fine people for having them. Now that's a worry. Secondly, landowners or their agents who had authorised the installation of temporary yellow signs on private land were instructed by a compliance officer of council to, quote, promptly make required adjustments to the signage. The justification for that direction was that the proposed district plan, apparently, according to this person, justified that claim, in particular Appendix 8. Our problem with that is the district plan is still in the appeal process, is not yet operative, and even if it were, Appendix 8, which was cited, is not relevant to temporary signs on private property, and therefore can't be used logically to deem the yellow signs in breach. This, again, from our perspective, is overstepping authority, overreaching the compliance officer's powers. But we do recall at a meeting of one of the committee meetings here, the strategy manager being asked quite directly, does this bylaw apply to the yellow signs? And the answer was quite precise. I looked at it again yesterday, was quite precisely, no, these bylaws apply only to directional signs and temporary event signs. It was a no by any reading of what she said. It was a definite no. But we want to see that assurance that the proposed amendments wouldn't apply. We want to see that honoured by the deletion of the phrase, but not limited to. Now, one of the reasons why we are so keen on not having any prejudicial applications, because we see them as potential violations of our democratic and civil rights. We have rights enshrined in law to freedom of thought, freedom of expression, and the freedom to make manifest our beliefs. So we ask you, please, with respect, to comply with those rights that are guaranteed in New Zealand Bill of Rights, to freedom of thought, freedom of expression, and freedom to make manifest our beliefs. The yellow signs can be read as a symbol of our democratic and civil rights. If you violate them, you must expect that the Residents and Ratepayers Association will take umbrage, will take a very dim view of any violation of our civil and democratic rights. The final part of our presentation is that we understand, and here's the group of criteria that he used, the legal validity of a bylaw must be compliant in 4 respects. Otherwise, it's subject to challenge. It's challengeable. The first is there must be an Act of Parliament in place that empowers Council to make a bylaw. Now, you have that authority. You have that bylaw. But secondly, the bylaw must not be repugnant to the general laws of New Zealand, and we would say an attempt to apply this bylaw to private signs on private land would infringe our democratic rights to ask questions of the public. Number 3, the logic of the bylaw itself must be compelling. This is an internal logic to the bylaw, or it will fail the test of certainty. And the example we've given you is the example of ambiguous definitions that could allow for prejudicial applications. That's the test of certainty. The final test is it must be demonstrably reasonable and not violate democratic and civil rights given expression by our yellow signs. That ends my submission. Thank you very much for hearing, and I'd be happy to answer any questions about our submission. Kia ora tātou.
The questions, Councillor Kent, Councillor Gould.
Thank you, Your Worship. Good morning, Mr McPherson. Thank you for your submission, which is very thorough. And thank you for pointing out the ambiguity in the definition of temporary event signage and directional signage. In reality, I think the issue is caused by failure to comply with the common usage as defined in law. And the common usage as defined in law is usually expressed as including, comma, but not limited to, comma, an event. And if you insert those 2 commas, I think it will actually remove the ambiguity completely from the statements, as you suggest. Would you perhaps agree to that?
First, thank you for your comments about the quality of submission. I will freely acknowledge that on an earlier occasion, it was your help in the preparation of a prior submission that gave me access to this genre and helped me learn, so thank you very much. So the quality derives from your own work. The solving of the ambiguity by putting in commas, I'm not sure how that would prevent the prejudicial prejudicial application of that statement. Our worry is that it could be interpreted as it includes, but it's not limited to. Even the insertion of commas could lead to a subsequent occasion down the track where people want to transport these criteria from this bylaw across into other activities. So I'm not sure about that. I would like to have a legal opinion on that. But thank you for your question.
Councillor Gould.
Yeah. Thank you for your presentation today, Dr McPherson. Your presentation, on a number of occasions you mentioned yellow signs, but individual people can put whatever colour sign they want up as a background. Are you trying to just going after just the yellow part, or are you stating your case for any particular colour sign?
First of all, thank you for the restoration of my doctorate. It was hard-earned. It's nice to have it back. I appreciate that. Secondly, the colour of the signs is not in itself significant. It's what, to us, it represents. Our capacity to be able to put up signs on private land that give expression to our concerns, our values and so on, is very, very important to us. The yellow and black is a decision made on the advice of people who understand how to catch people's eyes. But I'm not here to discuss in any sense at all the aesthetic qualities of the yellow and blackness, the yellowness and the blackness of our signs. I'm simply here to put forward the ideas that I have submitted, that we're deeply concerned about prejudicial applications of this bylaw outside its boundaries, by being absolutely clear about its definitions, and secondly, by ensuring that we're allowed to defend and sustain our democratic and civil rights. We won't compromise on that. But thank you for your question.
Councillor Weber.
Thank you, Madam Chair. Look, I just thank you for coming in today. I just wanted to clarify, just so I've really got it clear, that you're really concerned about private signs on private land, aren't you? That's the biggest thing, apart from the wording, I understand. So that's your biggest, which is really a district plan issue, not a traffic bylaw issue. That's the main point, isn't it? Apart from the words, they're not limited to, I get all that, but it's the private signs on private land, our application of that, which
Yes.
is a district plan issue, not a traffic signs on bylaw issue.
Before us, we have a bylaw being proposed by this council.
About event, and the point you raise is event directional signage.
That's
But
right.
you're mixing up the district plan rules with this.
No, I'm not mixing it up at all. What I'm saying is
I'd
that
like-
the proposed bylaw before us could be interpreted as being applicable to private signs on private land. And we would advise against that. We're taking a position of saying, please don't do that, because it's outside the remit of this bylaw. The words of this bylaw could be interpreted to mean they can be applied to private signs on private land. And we would suggest, don't permit that potential application, that potential interpretation of the definition.
Could I just add to that? So with the privates, so we have different rules for private signs on private land that is administered through the district plan, and you mentioned that earlier when you were speaking, that you don't understand how it's been interpreted by staff. So are you aware that if something is not under appeal at the moment, that staff have to weigh up the operative plan and the proposed plan and give them a certain type of weighting depending on where we are in our process of the district plan, if that part is not under appeal? Did you realise that?
My understanding from what I read at your website is that your district plan, your proposed district plan, is not yet operative. The components that relate to signage, it's not a matter of not understanding, it's a matter of a precise reading of what's on your website about the district plan, the proposed district plan, not being operative, in which case it can't be applied as it has been. It should not have been applied in the way that it was applied by the compliance officer.
So I'm not suggesting that you don't understand. Sometimes our wording needs to be improved, and certainly we're open to that. I would just like to say, if a part of a district plan isn't under appeal, that staff weigh up the operative and the proposed when making decisions. So if I could just clarify that.
Thank you. I appreciate that clarification.
And we may need to approve the wording.
Right. My point would be, on behalf of our 400 members, we would not want the discretion that current situation provides to a compliance officer to be used in a prejudicial way. That is, to us, it's a remarkable piece of overreach. We would want a very, very careful consideration of what is wise and what is sensible under the proposed district plan, which is not yet operative.
Thank you, Dr. Reynolds. There are no more questions. And thank you.
Thank you very much to all of you. Kia ora
We
tātou.
move now to Bruce Horn, New Zealand Police. And Bruce, we're about to get your submission, I understand. Thank you, Bruce. The councillors haven't read your submission, and all submitters have got 10 minutes. So if you can, we can't really take this as read because we haven't had time, but it may raise some questions if some councillors can speed read. But we felt we would accept the late submission.
Thank you. And apologies for that. Just by way of guiding the councillors through the submission, the first part of it is really dealing with some background and some general principles that some of you will be quite familiar with in respect of crime science and crime prevention through environmental design. I've then moved to some specifics and some research that we've looked at in respect of the problem of window washers internationally. So it comes down to 4 key points to our submission, and those are these. Firstly, the international literature, in the States, they talk about panhandling, which covers all sorts of activity from people begging on the street, which they would refer to as a passive form of panhandling, to more aggressive types of begging or panhandling, which is the window washing type. Enforcement action against begging, where people are passively sitting on the sidewalk, tends not to be too effective, but enforcement action against aggressive forms of panhandling, such as window washing, has found to be effective. And so that's the first point. The second point would be that our experience in Rotorua mirrors that, again, of what's experienced internationally, and that a lot of people that engage in the window washing activity are convicted criminals, do have drug alcohol problems, not all, but most, and aggressive behaviour from those people, often because of their drug alcohol problems, is commonplace. Although I haven't given you this information in the submission, a question that I anticipate is how many reports we have received or complaints from the members of the public about this behaviour. I can advise that there are a lot, but actually trying to trawl through that information is very difficult because there isn't a specific offence category for this type of behaviour. So when it does get reported to the police, there's a dozen or so different codes that it could be logged at by our communications centre, so searching for that information. But I can advise that we do receive a lot of complaints, and in fact we just received one the other day where the guy was so aggressive, and this wasn't even before it got to a dispute over money. He hadn't asked for money, but he was so aggressive and reckless in the way that he's washing the windows that he snapped off this person's windscreen wiper blade. Yeah. And so when they got out to sort of have a discussion about that, the guy threw it on the ground and ran off. So that sort of complaint and behaviour is common. In terms of, so our next point would be that if the council was to look at putting some more rigour around a bylaw for this, police would certainly support it because we are getting a lot of complaints about it. And in terms of the technical application, preference would be if, and I'm not too sure of all the mechanics of this, but we would prefer to have it dealt with by way of an infringement notice, such as the liquor offence infringement notices which are used at the moment. The problem with a summons process, particularly given that a lot of these people are often very transient and difficult to find, it's a very cumbersome process that would actually create a lot of work in terms of the follow-up, in terms of trying to find them to serve a summons and then get them to court. So an infringement notice would be the most efficient way of dealing with it, and probably set at an appropriate level given the type of behaviour it is. And that's my submission, ma'am.
Thank you, Bruce, for that. And are there any questions? Councillor Gould and Councillor Weber.
Thank you, Bruce, for your submission today. My question is based on signage, but it's not mentioned in your report. Signage on the footpaths. Have you got a ruling for that? You know, at the moment in Auckland, they've got a lot of problems with particular areas, and we are slowly getting that particular problem in Rotorua in the CBD.
I may have to rule that out. This submission is on window washers. our line of questioning really should be related to the request that we consider a bylaw on window washers. You might want to answer, Bruce. It's sort of caught you off your submission.
Sorry, I'm more than happy to give an answer. Effective signage works really well, but the key to is it being effective. A good example would be, and I've talked about this in the submission actually as an example of a really successful joint council police project called Project Papawaka, and that was kicked off about 2006, 2007, where we treated the 13 most high-risk car parks for tourist car crime in Rotorua. And at some sites we had a 100% reduction, and we had a 50% reduction, which is carried on through sustained reduction. But the key to that was the science around the signage. Advocates against signage will talk about visual clutter, and that's certainly an issue. So if you're going to, the idea being that you try and get everything brought into one. So what was very effective about the signs for Project Papawaka is, first of all, is that they were large and they had a map on them. So it was appealing to the people that go into those areas. They're looking for information. They see a large sign with a map, it draws them in. And then all the information that they needed to know, as well, both the visitor information but also the safety information, was weaved into the one document, the one piece of writing for them. So it just worked them through. And that was found to be, it was a far more effective way of communicating the information and people taking it on board, rather than having a whole series of signs that people have to read. Because often the lock it or lose it, which has now become very familiar, people see that, yeah, I know all that, I want to know about what I can do at this place. So if you're looking at signage around the CBD, as for example, we would encourage a similar approach where you had all your information you're wanting to convey to people in one place, so it draws them in and works them through it.
Thank you. Councillor Hunt, then Weber, then Councillor Tapsell.
Thank you. Thank you, Inspector Horn. Are there particular hotspots around that are intersections that are more favoured over others? That's one question. And are they generally individuals or teams working? And are you, and I guess us by definition, expecting that the implementation of the new CCTV network will assist in managing this issue?
So if I answer the last one first, which is the CCTV, and particularly developments in CCTV are tremendously helpful for police in all sorts of ways, so that would be a benefit. In terms of hotspots, there are about 4 or 5 locations where we're commonly encountering it. One is the old Taupo the old Taupo Malfoy intersection by the shops there at West End, by the Farmers Building in the CBD, the Kotu Corner, and Pack and Save. That's on the Amaho Fenton Street. Those are the 4 sites where we get most complaints from. But we're also starting to get complaints now where they're moving around in car parks such as the Central Mall car park and approaching people in the car park. A consideration with these things is also displacement. I anticipate that might be on some people's minds. And displacement is often seen as a bad thing. It isn't always, because people forget that sometimes you can't always remove a problem completely, but displacement is at least often minimising the problem. And there's quite a bit of research around this, for example, with drug dealing houses, and they've shut down the drug dealing house, and people say, well, it's opened up over here. But if you look at the impact of the new location and the crime around that location, it's often less than where it was before. So it does have a disrupting effect. And on other occasions, I remember there's this discussion occurring when we were working with council around the liquor ban some years ago, is that a lot of problems are associated with the CBD. For example, a lot of our tourist accommodation is focused in the CBD. So if you focus on the CBD, that's where the problem is, and it isn't going to displace, because there simply won't be those opportunities out in the suburbs, for example, because there isn't tourist accommodation there. So I would see this probably in a similar vein in terms of volume of traffic and opportunities for people that are engaged in this. Most of it's around the CBD. We're not encountering it outside the CBD at this stage. If there was a clampdown in the CBD, there might be some displacement, but I don't think it would be that great and it would be easily to manage.
Councillor Weber?
Madam Chair, and thank you very much, Bruce, for coming in today.
You're welcome.
I was surprised to hear you didn't mention Western Heights, unless the complaints just come through to council and not you, for window washer
On
issue.
Brooklyn Road?
Yeah, on Brooklyn Road.
Yes.
Oh, yeah, that's okay. Yeah, okay. So I just would raise that, but I've read through it very briefly as it's been tabled. But what are you asking for more than what we're suggesting in our new traffic bylaw, where there will be some powers to the police? Are you asking for more? What else do you think we could do?
Our submission is simply we support any action. We support the general thrust of the council's intent to legislate against this, and in terms of the enforcement action, looking at the mechanics of the enforcement action, we would like it, if it can be done by way of an infringement notice rather than a summons process, and that would just make it much more manageable for us to use the legislation in an effective way, because it's not in anybody's interest to pass a law that then becomes difficult to enforce through the mechanics of it, and that's the issue that we're raising there.
So in your opinion, if we could do that, an infringement notice, do you think
Absolutely.
would work?
Yes.
Would
Yes.
be a sufficient deterrent?
Well, and because if the process is difficult, police staff won't do
Right.
it. I can encourage them, but it's going to be a barrier to staff taking action, because they're going to think there's a whole lot of red tape involved in taking this action, whereas an infringement notice is a really easy way to deal with it.
Have you any idea of the level?
Of fine, I haven't turned my mind to that, to be honest.
Okay, that's all right. Thank you.
Councillor Tapsell?
Thank you, Madam Chair. Thank you, Bruce, for your submission and also being here to present. It's very valuable having your insight. My question is just in regards to the general consideration found at the back of your report on public education to discourage people from giving money to window washers. Now, I know we've successfully worked on a few projects with the police and the council on the safety around Rotorua, but I was just wondering, in terms of the public education, do you see that as like another partnership project between the police and the council, or are you suggesting that we as the council create awareness around that?
All right, either, but we would happily support a joint project.
Thank you for coming. Could I just add that this is an issue that did arise from Western Heights, and as a result of that we took a recommendation to Local Government New Zealand Council for consideration at their level, and I'm not sure New Zealand Police's response, would they all support the infringement aspect? Bruce, do you think?
I would.
Rather than the power of enforcement by local body officers? Are you saying it's a much simpler mechanism?
Yes, and certainly you'd find that at from our National Prosecution Service Centre, they would be encouraging, because it's for the courts as well. It's a much more efficient process than going through a summons process where people have to appear in court.
Yeah. Thank you. That's helpful, and we'll feed that back through to Local Government New Zealand too. Thank you. No more questions. And there are no deliberations today, but thank you for coming.
Thank you.
And
Good to see you all.
Commander Horn. And I declare the meeting closed.